Rubin Center for Education. This program is being recorded, and therefore it's necessary for me to mention that today is October 21, 2014, and today's program is entitled Justice Robert H. Jackson, Chief Prosecutor at Nuremberg, the Connections to Rochester and Related Topics. We want to thank again D4 for providing lunch for today's program. These are a few housekeeping ideas or items. CLE credits. In order to comply with accreditation regulations, would you please fill out your evaluation sheet at the end of the program and drop it in the tray located at the exit door. In exchange, you may pick up your certificate of attendance, which will be arranged in alphabetical order on the table at the door. Please note that all attorneys must attend programs in their entirety in order to receive credit. According to New York State Continuing Legal Education Board, CLE providers are prohibited from issuing partial credit. Cell phones, please turn them off or place them on vibrate. Flyers, remember to check out the flyer rack on new CLE programs that are being offered. Clean up at the end of the program. We would ask you to please return your cans to the back of the room and dispose of trash. The Center for Education has experienced an increase in the number of attorneys seeking tuition assistance in order to meet their CLE requirements. Scholarships are funded by voluntary contributions made by members when they pay their annual dues. In order to help meet this new demand, the Academy has decided to place a donation jar at the check-in table. When you leave today, please consider dropping $1 or $2 or more, for that matter, into the jar. Thank you. As you know, we have a very distinguished panel of speakers today, and let me briefly provide a short biography of each at this time, and I will provide them in the order in which they will present. First of all, to my immediate left, Honorable Henry J. Scudder, Presiding Justice of the Appellate Division, 4th Department. Justice Scudder received his undergraduate degree from Stetson University and his law degree from the University of Tennessee. He began his career in private practice in Bath, New York, and later served as First Assistant District Attorney in Steuben County before being elected in 1982 to be surrogate for Steuben County, a position he held from 1982 to 1996. He was elected to Supreme Court of the 7th Judicial District in 1996 and was re-elected in 2010. In 1999, Justice Scudder was designated by Governor Pataki to be a Justice of the Appellate Division, 4th Department, and on November 17, 2006, Justice Scudder was appointed Presiding Justice of the Appellate Division, 4th Department, and was reappointed to this position by Governor Cuomo in 2011. Next to Justice Scudder is Honorable Leslie G. Fascio, Magistrate Judge for the Western District of New York. Judge Fascio received his BA degree from the former University of Buffalo and his LLB from the State University of New York at Buffalo Law School, where he was comment editor of the Buffalo Law Review. In June 1996, he was appointed Assistant District Attorney for Erie County, and in February 1969, Judge Fascio joined the Notre Dame Law School faculty, where he served as an Assistant Dean and Associate Professor of Law until February 1975, when he returned to Buffalo to accept the appointment as Corporation Counsel of the city. He was appointed by Governor Carey to be Commissioner of Motor Vehicles for New York State in January 1981, and thereafter he served as General Counsel of the Barrister Information Systems until he was appointed by the district judges of the Western District of New York to the position of Magistrate Judge in February 1991. Third is Professor John Q. Barrett, St. John's University School of Law. Professor Barrett teaches constitutional law, criminal procedure, and legal history at St. John's University, and he also is the Elizabeth S. Lena Fellow at the Robert H. Jackson Center in Jamestown, New York. He obtained his undergraduate degree at Georgetown University and his law degree from Harvard Law School. Professor Barrett is presently writing a biography of the late Justice Jackson, which will include the first inside account of Jackson's service by appointment by President Truman as the chief prosecutor at Nuremberg during 1945 and 1946. 50 years after Jackson's death, Professor Barrett discovered and edited a previously unknown manuscript written by Justice Jackson, which is now a book entitled That Man, An Insider's Portrait of Franklin D. Roosevelt, which is a memoir of FDR from Jackson's first meeting him in 1911 through Roosevelt's presidency. I would definitely recommend you read it. I read it last week. It's a terrific read. And, of course, all of you have received, you should have received, a copy of it on your way in. Prior to joining St. John's faculty, Professor Barrett was counselor to the United States Department of Justice, Office of Inspector General. From 1988 to 1993, Professor Barrett was associate counsel in the office of independent counsel Lawrence E. Walsh, dealing with the Iran-Contra investigation. Last but clearly not least, Gregory L. Peterson, partner, Phillips Lytle, LLP. Gregory Peterson is a co-founder of the Robert H. Jackson Center in Jamestown, New York, and a partner and office leader of the Chautauqua office of the law firm of Phillips Lytle. His practice is concentrated in the areas of real estate, including development and financial transactions, and corporate counseling, including acquisitions. Greg received his BA degree from Allegheny College in 1973 and graduated Phi Beta Kappa. He received his Juris Doctor in 1976 from the Dickinson School of Law of the Pennsylvania State University. Greg is very active in a number of professional and community organizations in both Jamestown and throughout New York State. Now, before having each of our distinguished panel members address the topic, I'd like to provide you with some salient facts regarding Justice Jackson's life and remarkable career. And I'm sure the rest will fill in all of the blanks. Robert Jackson was born in 1882 and graduated from high school in Shrewsbury, New York in 1909 and spent the following year as a postgraduate student at Jamestown High School. At the age of 18, he decided against attending college and began his studies to become a lawyer. He first worked as an apprentice in the office of Jamestown attorneys Frank H. Mott and Benjamin Dean. And after 1 year, he enrolled in Albany Law School, which was then a 2-year school. He was accepted into a senior class since he was given credit for his apprenticeship year. He completed the academic program at the top of his class. At age 20, he returned to Jamestown, resumed his apprenticeship with Mott and Dean before he was admitted to practice before the Appellate Division, 4th Department, a little over 100 years ago, on November 24, 1913. Robert Jackson held a number of significant positions in the Roosevelt administration, beginning in 1934 when he was appointed general counsel of the IRS, and in that position he tried one of the most significant cases of its time. Now imagine, this is the general counsel of the IRS trying a lawsuit, and this was against multimillionaire Andrew Mellon, who had been Secretary of the Treasury under President Hoover. Thereafter, he held the position of Assistant Attorney General in charge of the Tax Division, and shortly thereafter assumed the duties as head of the Antitrust Division. He took over as Solicitor General of the United States on March 5, 1938. At the end of his first term as Solicitor General, and in view of the significant cases he had handled during that past term, Time magazine reported that this latest term was truly the term of Solicitor General Robert Jackson. On January 4, 1940, President Roosevelt named him Attorney General, and on June 12, 1941, President Roosevelt nominated him to be an Associate Justice of the U.S. Supreme Court, and he was confirmed shortly thereafter. He sat on the Supreme Court from 1941 until 1954, and during that time, he wrote more than 300 opinions. He took leave of absence to be the prosecutor at Nuremberg in 1945. His opinions are timeless in many ways, and they are often quoted at confirmation hearings of prospective justices. It happened repeatedly during the confirmation hearings of Justice Alito and Justice Roberts. One of the cases that stands out is his concurring opinion in the case of Youngstown Sheet and Tube Company versus Sawyer, which dealt with President Truman's attempt to place most of the nation's steel mills under federal control in order to avert a strike which would have adversely impacted the country's effort in the Korean War. The Supreme Court ruled that the president lacked constitutional authority to issue such an order. Justice Jackson's concurring opinion, which formulated a 3-tier test for evaluating claims of presidential power, remains one of the most widely cited opinions in Supreme Court history. The portion of Justice Jackson's opinion, which is often quoted, is the following. When the president acts in the absence of either a congressional grant or denial of authority, he can only rely upon his own independent powers. But there is a zone of twilight in which he and Congress may have concurrent authority or in which its distribution is uncertain. Therefore, congressional inertia, indifference, or acquiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables rather than on abstract theories of law. On a lighter note, in the case of Securities and Exchange Commission versus Chenery Corp. In 1947, Justice Jackson wrote in his dissenting opinion the following: "The court's reasoning adds up to this. The commission must be sustained because of its accumulated experience in solving a problem with which it had never before confronted. I give up. Now I realize fully what Mark Twain meant when he said, 'The more you explain it, the more I don't understand it.'" Following his service as the prosecutor at Nuremberg, Jackson returned to the United States and resumed his work on the Supreme Court and participated in the unanimous and epic decision of Brown versus the Board of Education of Topeka in May of 1954. A few months later, on October 9, 1954, he suffered a heart attack which proved to be fatal. He was only 62 years of age. He lies buried in Maple Grove Cemetery near Jamestown, New York, under a simple headstone that reads, "He kept the ancient landmarks and built the new." Please join me in, first of all, welcoming Justice Scudder, who was our first presenter. Justice Scudder.
As you know, Justice Jackson was admitted to the practice of law by the 4th Department pursuant to Section 90, Subdivision 1 of the Judiciary Law of the State of New York, which vests in the Appellate Division of the Supreme Court the authority to admit qualified individuals to the practice of law. Qualification requires certification that the individual successfully passed the state bar examination and possesses the necessary character and fitness to practice law. Due to the nature of the qualification process, however, the judiciary law in Section 90 sub 10 provides that all papers, records, and documents related to the application or examination of any person for admission to practice as an attorney shall be sealed and deemed private and confidential. There is an exception to the confidentiality requirement if the court, upon written application, finds that good cause to divulge all or part of the bar admission file has been shown. No such finding had been made by our court in the first 117 years since it was created, until last year, when an application was made to us by Justice Jackson's scholar and law professor, John Barrett. Sometimes at trial or on appeal, you need more than facts in the law. You also need a deserving client or a just cause. In this case, the bar applicant was both a national and international figure of historic significance as a former justice of the United States Supreme Court, who also happened to be the chief prosecutor at the Nuremberg trials. Neither the applicant nor anyone else, nor anyone referenced in the application was still living, and the disclosure was limited to educational and other scholarly uses. Hard to turn that application down. I suspect, however, that it likely will be the first and only exception to the confidentiality rule made by the 4th Department. The Jackson application file, when it was first pulled by our staff from the permanent bar admissions collections, looked to have been untouched or exposed to the light for the last 100 years. With the help of our law librarian, who serves as our who serves in that area of our library, the application and letters of good moral character were carefully scanned and sent to Professor Barrett and the Robert H. Jackson Center in Jamestown, New York, for public display. Due to the fragile nature of the ink and paper, especially if combined with hand oil, however, we could not expose them to additional light or handling by circulating them to you today. Instead, we've placed the original documents under glass in a display case and have put scanned copies of the application in a folio that you can see and read. And it is interesting reading. For those of us who enjoy history, the bar admission record is like a snapshot in time. Justice Jackson was admitted to practice by our court on November 24th, 1913, at the age of 21, never having attended college or having graduated from law school. Times were very different back then. For one thing, schools clearly still taught the Palmer method of handwriting, for those of you who may remember that. And as you can see, when you look at the document, Justice Jackson's writing is clear and legible, unlike mine and some other people I know. What is also apparent is that the application at that time was simple and straightforward, only 4 pages in length, consisting of 9 questions, with plenty of space between for the handwritten answers that sought basic information: name, age, residence, birthplace, educational and employment experience, prior applications or admissions to the bar, prior business or professional endeavors, and a list of character references. In Justice Jackson's case, his character references included the Dean of Albany Law School, his high school principal, the president of his local bank, a family doctor, the district attorney of Chautauqua County, and the president of the Chautauqua County Bar Association. One of his 2 affidavits of moral character came from attorney Frank H. Mott, the man who allowed him to learn the law by studying in his office for 1 year after high school and again after Jackson completed law school. By contrast, the current bar admission application is almost 5 times as long, at 19 pages consisting of 45 questions, most of them with multiple subparts requiring such information as educational disciplinary history, unauthorized practice of law, military, disciplinary, and criminal records, fraudulent conduct, outstanding debts, mental condition and impairments, substance abuse, and addictions. Some might conclude that the information sought paints a far different perspective on the legal profession today than it did in 1913. We've also provided you with a list of cases, I hope everybody has one, with citations in which Justice Jackson appeared as counsel, either on the brief and or on oral arguments at the 4th Department. His first case appears to have been in 1918, some 5 years after being admitted to the bar, in the case of Rott v. International Railway Company, 185 AD 191, a personal injury case. Justice Jackson represented the defendant company both at trial and on appeal. The brief is short, 9 pages, covering 4 points, and the writing style is clear and persuasive. The plaintiff, according to Jackson, set up 2 separate causes of action, claiming to have been twice injured by the defendant's neglect in the incidents 2 months apart. Her husband brought 2 separate actions for his expense and loss of society and services. Defendant disputed liability and damages as to the first incident while conceding liability but disputing damages as to the second. The trial court rejected Jackson's request for separate verdicts. On appeal, Jackson argued the refusal was clearly error because it made it impossible to determine whether the damages were excessive. In his words, the appeal cannot be presented in clear-cut fashion, for we are entirely in the dark as to what the jury have done, except to beat us. Whether upon both causes or whether upon only one, and that one at war prices, we are unable to say. In what may have been his last appeal to the Fourth Department after his last trial as a private attorney, Jackson appears confident in his mastery of the record and issues, urging affirmance of a judgment dismissing the New York Telephone Company's action to recover money from the Jamestown Telephone Corporation under an agreement to compensate phone companies for what some of us older attorneys recall as long-distance toll charges. Jackson's brief is 66 pages in length and raises 7 points. Interestingly, the brief was written in 1939 when Jackson was already serving as U.S. Solicitor General. The Fourth Department is extremely lucky to have the largest court library in the state with a 300,000 volume collection, including the records and briefs of all the Jackson cases cited on the list that's been circulated to you. All you need to do to see them or read them is contact our library, and we'd be glad to make them available. Thank you. Oh, one more thing I forgot is we have 2 folio thing that we're going to leave out, and Rob Cunningham is going to be there, that shows pictures, and also shows the application itself, but shows pictures of Jackson that were taken and then sent to news organizations. They were then put in archives, and now they're selling them, all right? So we have the original, as it relates to, if it was the Baltimore Sun or whatever, the original picture that they used in order to put in the paper, and you can see where they cropped it, and also the original note that went with it to explain what the picture was, and their own little thing on it saying that this is the Associated Press or this is whatever. So we're really proud to have that, and Rob will stay for if anybody's interested. All right, thank you.
I take it the material from the appellate division is available on the table right outside?
Right here.
You got it right there?
Got it right
Okay,
there.
great. All right, our next speaker is Judge Fascio. Please join me in welcoming Judge Fascio.
It's a great honor to have been asked to participate in this program. I'm always humbled to have anything to do with Robert Jackson's memory, and to be on this distinguished panel, of course, is a special occasion for me. I want to, at the outset, thank our court librarian in Buffalo in the federal court, Jay DeVoe, for helping me to assemble these materials, and also to Robin Carlton, the appellate division's librarian, in bringing up some of the Jackson briefs that Justice Scudder already alluded to assist me in preparing my remarks. Mike Wolford suggested that in order to make a connection between Jackson's practice before he achieved the pinnacle of the profession would be to survey the federal court cases that he may have been involved with in the Western District for the 20-year period of his private practice years before going to Washington, approximately 1915 to 35. I was able to only locate 3 reported cases, and because of limited time to prepare the remarks, it was not possible to attempt to retrieve the briefs that were probably submitted by the parties from federal court archives Further, Jackson probably appeared in many other cases before Judge Hazel in his private practice years, but Judge Hazel, who was the only federal judge in the district in that era, his decisions are, of course, not published in all cases, and there's no Westlaw or Lexis to rely upon. Nevertheless, I thought it would be interesting to learn of the types of matters which Justice Jackson handled either through his law firm or personally. And the first case that I discovered was the case of City of Jamestown versus Pennsylvania Gas Company, Western District of New York, February 5th decision by Judge Hazel. The co-defendant was National Fuel Gas and was represented by Dean, Edson, and Jackson of Jamestown. And it appears that Justice Jackson was the principal lawyer on the case. In this case, the City of Jamestown requested a temporary injunction to prevent the defendants from terminating supplies of natural and manufactured gas to users of light, heat, and power in the city, pending a hearing on the city's request for a permanent injunction. The gas piped from Warren, Pennsylvania, had been supplied pursuant to a franchise approved by the then Village of Jamestown in 1885. Jackson's law firm's client, co-defendant National Fuel, was the majority stockholder of Pennsylvania Gas and owned gas fields adjacent to those of Pennsylvania Gas, and had been supplying and was expected to continue to supply natural gas to its City of Buffalo customers thereby, the plaintiff alleged, creating a discriminatory supply policy between the two cities. Jurisdiction was based on diversity and irreparable injury in excess of $3,000. Defendants moved to dismiss based on lack of jurisdiction because the defendant Pennsylvania gas fields lay outside the court's geographical jurisdiction, lack of equity, and misjoinder. Not realizing that he was rejecting the views of a future Supreme Court justice, talk about judicial independence, Judge Hazel nevertheless overruled all three of defendants' arguments. Judge Hazel found, contrary to the defendant's citations, that although the plaintiff's damages were not subject to exact measurement, a fact which ordinarily would counsel against exercising the court's equity jurisdiction, that plaintiff as a municipality could enforce valuable franchise rights, and that defendants' cases were not apposite, because the inhabitants in this case were entitled to the benefits of the franchise, which the city as the real party in interest could enforce. Judge Hazel also found that because the franchise was without any time limitation, the benefits to defendants and the city were perpetual, and thus not a revocable license, or a mere grant of permission. Thus, the city, as Judge Hazel found, could enforce the contract as long as defendants remained in the gas utility business and performance was not factually impossible. That is to say, any exhaustion of gas available to be captured and supplied. Judge Hazel thus rejected defendant Pennsylvania Gas's assertion that because its charter did not require it to fulfill the franchise indefinitely, it could relinquish the franchise, and instead concluded that the franchise was a binding perpetual contract for gas service. Judge Hazel also rejected National Fuel's argument that it was not a proper party co-defendant, finding that plaintiff could prove that National Fuel controlled Pennsylvania Gas and was in effect trying to favor its Buffalo customers at the expense of Jamestown residents. 2 months later, Judge Hazel in the same case granted the temporary injunction. In this opinion, Judge Hazel disagreed with the defendant's argument that because the defendant's gas fields were outside of New York State, the court lacked in rem jurisdiction. Instead, Judge Hazel found that the corporate defendant's general appearance in this case established personal jurisdiction to enforce the franchise as a contract, and thus provided sufficient jurisdiction to issue the requested injunction to preserve the status quo pending a trial on the merits of plaintiff's complaint. He also rejected the defendant's creative contention that the issue should be litigated in Pennsylvania as a matter of comedy, advanced by the defendants because the injunction would require defendants to drill additional gas wells in Pennsylvania and add new compressors in order to maintain gas service to Jamestown. Judge Hazel rejected this argument out of hand by noting that these burdens had long ago been assumed by the defendants when they accepted the franchise. Defendants also claimed that Pennsylvania Gas was by state law required to supply gas to the cities of Erie, Corry, and Warren, Pennsylvania, and that because the Pennsylvania Public Service Commission had commenced an investigation concerning an alleged diminution of defendants' capacity to continue to provide gas to these cities at an acceptable level, the court should not interfere in deference to the state's initiative. But the court also rejected this contention, again noting that Robert Jackson's client, National Fuel, controlled Pennsylvania Gas and that it owned large gas fields adjacent to those of Pennsylvania Gas, and that whether the fields were adequate to supply all of the cities was a question of fact for determination at a hearing on the plaintiff's permanent injunction request, subject to future modification in case of a conflict with state mandates. A careful reading of the decisions show Robert Jackson's ability to sort out and address interesting complexities of interlocking private and public law, corporate charters, public franchises, and related principles of contract law and government regulation, issues that would later resonate after Jackson went to Washington to successfully defend his sponsor FDR's New Deal legislation and his careful construction of creative arguments based on existing case law. The third reported case involved Jackson's firm, which involved his firm, was O'Grady versus Chautauqua Builders Supply in 1929, a bankruptcy case in which Jackson and his firm successfully defended Builders Supply, a building supply company, against the claim that the bankrupt paving company, Neal's Brothers, had allegedly made a preferential transfer of assets while insolvent, 3 steam shovels, and other items, within 4 months of a petition for involuntary bankruptcy. The issue was whether, because the bankrupt failed to include several liabilities in a financial statement prepared by the bankrupt upon which Jackson's client relied in accepting the disputed asset transfer in order to take over the bankrupt's road repair contracts, Jackson's client knew or had reason to know that the insolvency of Nealon's then existed and that the asset transfer would therefore constitute a preference under Section 60B of the then Bankruptcy Code. However, because the evidence showed that the defendant had genuinely believed that the bankrupt Nealon's was not insolvent when defendant assumed its road building contracts to secure the bankrupt's debt to the defendant, Judge Hazel refused to find the transfer of assets in order to carry out the road contract by Jackson's client, which contract resulted in a substantial loss to the client, was recoverable by the trustee as a preference. This case represents an example of routine business litigation typical of the region in which Jackson practiced, involving suppliers, banks, and insolvent road repair companies, a scenario not unfamiliar even in the current era. Careful presentation of the details of the disputed transaction as a whole, including investigation of the key facts such as the client's reliance on the bankrupt's bank's opinion that the company had substantial net worth, and taking detailed testimony of witnesses, including the client's corporate officer who performed the due diligence, enabled Jackson to achieve a winning result for the client. Careful marshaling of key evidence, together with a straightforward application of the relevant legal principle standards, distinguishes Jackson's successful litigation technique in this case. As to state practice, according to my research, Robert Jackson or his firm appeared in some 14 reported cases in the appellate division. I'm not sure that's the exact number, Judge, but I'll look at what your librarian came up with. Warring librarians here, potentially. One of the most prominent of those matters was the successful defense in the appellate division of an appeal by Allegheny College that was not picked because of Greg. I did not know that he was a graduate of Allegheny College. This is a famous case that you probably remember from first-year contracts, right? Which had sued the National Chautauqua County Bank of Jamestown and state Supreme Court to enforce an estate pledge by the decedent Mary Yates Johnston. In 1921, Mrs. Johnston executed a pledge promising a gift of $5,000 to the college. That would be, I'm told, about $60,000 in today's dollars, to be designated as the Mary Yates Johnston Memorial Fund. She made an initial payment of $1,000, with the $4,000 balance to be paid from her estate to the college for its second century endowment fund, part of a $1.2 million fundraising campaign, a large number for that era. Mrs. Johnson paid the first $1,000, but she later revoked her pledge as to the balance. Don't know why, Greg. I'll let you find out what happened there. On behalf of the estate, which refused to pay the putative gift balance of $4,000 to the college, Robert Jackson argued the instrument was neither a promissory note, a pledge of personal property, nor a testamentary bequest, because the prerequisites of a will were absent, and particularly that no contractual liability accrued against her personally during her lifetime, enforceable against Mrs. Johnson's heirs as a debt, because the putative gift could not be a contract as it was without consideration, in that no promise or detriment was assumed by the college to support Mrs. Johnson's promise to pay the gift out of her estate. In support of this contention, Robert Jackson cited to earlier New York case law, such as the famous Hamilton College case, 1845, before the then New York Judicature Court, the highest court before the Court of Appeals came into existence, and the Presbyterian Church of Albany case in 1889, cases holding that a promise to make a gift by signing a subscription was unenforceable for lack of consideration. Jackson argued these cases were to be distinguished from the later famous Keuka College case in 1901, which enforced a charitable pledge of $500 to establish the college known as Keuka College, because the founders' subsequent action of soliciting the other pledges required to found the college established the consideration necessary for the agreement to make the gift enforceable as a contract. Agreeing with Jackson, the Fourth Department affirmed unanimously the trial court's dismissal of the case, a panel which included presiding Justice Irving G. Hubbs of Pulaski and a Cornell Law School graduate, and Justice Charles B. Sears of Buffalo, for whom the UB Law School Library is named, and who also incidentally was a mentor of Robert Jackson. The college's appeal, however, to the Court of Appeals was successful, with the court's holding 5-2 in an opinion by Chief Judge Cardoza that the subscription agreement for the $4,000 balance of the pledge was enforceable as a contract by Mrs. Johnston, who made the gift against her estate based on a finding of consideration arising from the college's implied mutual promise to perpetuate the donor's name as part of its endowment fund. Judge Cardoza also alluded but declined to rule solely upon the doctrine of promissory estoppel, finding instead the mutual promises of the parties supplied the consideration necessary to support the pledge as an enforceable contract to make a gift in 1927. Although Robert Jackson, despite his thorough reliance on common law cases to enforce strictly the ancient notion of consideration, ultimately lost his case, the decision of the Court of Appeals helped pave the way for the multi-million-dollar charitable giving industry based on liberalized notions of consideration to include offers for unilateral contracts and promissory estoppel as a rationale to enforce charitable pledges, doctrines which I believe are still enforced as a matter of common law in the state of New York today. 4 other cases are illustrative of the broad range of Robert Jackson's litigation practice and skills in the Appellate Division, 4th Department. In Gates versus Prudential Insurance Company in 1934, Jackson successfully defended against a disability insurance claim based on the plaintiff's quarantine as a typhoid fever carrier. One of his opponents was Alger Williams, later a presiding justice of the Appellate Division, 4th Department. In Miller versus National Chautauqua County Bank of Jamestown, Justice Jackson then successfully argued the constitutionality of the newly enacted Federal Bank Conservation Act intended to establish confidence, or renewed confidence, I should say, in the U.S. banking system during the Great Depression, relying on the currency clause and arguing that the regulation of the national bank in regard to this issue of bank stability was an exercise of the currency clause power, and that national banks as such were an instrument of the federal government in distributing and administering the currency system of the country. In that decision by the Appellate Division, Justice Thompson, speaking for an unanimous court, quoted McCullough versus Maryland and Chief Justice Marshall's famous dictum with respect to the implied powers under the necessary and proper clause of the Constitution. And that decision was not appealed. It was before the court, as I recall, on an agreed statement of fact, Justice Scudder, and I'm not sure whether Section 546 of the Civil Practice Act of the era was carried over to the CPLR, but that's how it got ruled on by the appellate division at that time. In Forbes versus City of Jamestown in 1925, Justice Jackson succeeded in obtaining a new trial in a case accusing the city of polluting the Cassadaga Creek with sewage, carrying typhoid fever germs which contaminated cows on plaintiff's downstream dairy farm, allegedly causing the spread of the fever among plaintiff's milk route customers. Sounds like a first-year moot court issue, but nevertheless, it really happened, and he succeeded in getting a new trial. And of course, you heard from Justice Scudder about the Rott case, which I will pass over in the interest of time. This brief survey demonstrates that in his climb to professional greatness, Jackson was a successful working lawyer practicing in the local judicial trenches in a wide variety of matters, cogently and skillfully applying a strong grasp of common law principles to both routine and complex legal problems. By the way, there is a show and tell copy of his brief in the Allegheny College case for your perusal and edification.
All right, thanks, Judge. Let's join me in welcoming Professor Barrett.
Thank you very much. I really want to do a few more thanks because a lot of people have contributed to this process. Mike Wolford first, Louise Spinelli of the Bar Association, Fran Caffarel and her colleagues of the 4th Department for the historical archival work, and Presiding Justice Scudder and his colleagues for the disclosure order. Now, Robert Jackson felt very strongly that a judge's work was simply a task to be done, and the individual works toward the right answer. And thus, it's not really appropriate to thank a judge for a result. And I think that might be a wise perspective on adversary litigation. Luckily, I had no adversary when I petitioned for the disclosure order, so I think it's an exception, and I'd like to directly thank you, sir, for the court's contribution to history by disclosing those orders. Now, what I'd like to do is 2 laps, if you will, and these remarks all dovetail very nicely. I want to use some visual imagery to walk you through Jackson's life, and then in the second lap, I want to return to pieces of that life that connect directly to Rochester. The first image is Jackson. I was told to point it at the laptop.
Where's Louise when we needed her?
Yeah.
Voice control.
Left hand. I can do this manually. Let's start at the very beginning. This is not a 19th century photograph. This is a 20th or maybe early 21st century photograph of Jackson Hill and a farm valley in Warren County, Spring Creek Township, Pennsylvania. It looks now a lot like it looked then. Jackson's great-grandfather was a Continental Army soldier and a resident of Litchfield, Connecticut, and late in the 18th century, he and a buddy decided to head west and explore. They got as far as the Ohio Reserve, the Indian Territory. They lived inside a stockade fort. They fought a little bit, and they had to live in the conditions of Indian warfare, and retreated to this valley and decided this was the place to begin to clear the land and build a log cabin, et cetera, et cetera. 3 generations later, this is Elijah Jackson. He had a son named Robert Jackson. He had a son named William Jackson, and he had a son named, again, Robert Jackson, Justice Jackson. So down through that 19th century story, this becomes the Jackson family farm and homestead. Now, it's on the outskirts of this thriving downtown metropolis of Spring Creek. This is the main street, and you can see a cutter, a sleigh, dimly. It's a pretty grainy photograph pulled up on the side, and that's snow covering the mud street. It was always much easier to get around in the winter, which gives you a sense of road realities in Jackson's time. And on the outskirts of town, back in that valley, but now we're looking at a much older photograph, this is the house that Elijah Jackson, after the log cabin built, and then it was his son's house, and then it was his son's house, and in 1892, this is where Robert Jackson was born. His parents were hardworking farmers. They'd been married about 8 years before this baby came along. They didn't think they were going to have children, and then all of a sudden, they began to appear. This is a family photo. They, I think, generally understood the mechanics. Historical records tell us no more. This is the hardworking couple. His mother, Lina, is on the left. His father, William Eldred Jackson, is on the right. Behind Will Jackson's left elbow is a hired man and a horse's ass. And on the other side of the picture is an elderly bachelor uncle who lived with them and was live-in childcare for young Robert when he appeared. He, the great uncle, took the boy out on horseback as soon as he could manage not to fall off, and taught him to ride, and taught him to shoot, and taught him to hunt, and taught him which plants you could eat and which ones would kill you, taught him to fish, etc. And Robert Jackson, for all of the sort of indoor work that is part of his greatness, intellectual achievement, adjudication, etc., was really a country boy, a farm boy, a county seat lawyer at heart throughout his life. And I think those two pieces you see in his writing, you see in his activities, you certainly see in some of his hobbies. Will Jackson, the father of young Robert Jackson, was not at heart a farmer. He was a man who could feel the coming 20th century. And pretty quickly, he got out of the farming business and moved the family up across the state line into New York State. They settled in the little village of Frewsburg. This is a picture of the Hotel Jackson, which was one of Will Jackson's many ventures during Robert Jackson's boyhood in Frewsburg. Luckily, they got the photograph before the fire burned it to the ground. Will Jackson also ran a livery stable. He bought and sold and housed and cared for horses. He owned the first automobile in Frewsburg early in the 20th century. He raced horses. He harvested lumber and chipped it and shipped it down the river. He did all kinds of things. He also drank, and no doubt that shortened his life. It led his son to be not only quite abstemious, I think, in his own personal behavior with regard to alcohol, but to write a very poignant sentence in a U.S. Supreme Court decision in the 1940s about one having seen the toll that alcohol can wreak, etc. And then he goes back to the legal issue in the case. It's just a little glimpse of an alcoholic son, and it's a very typical glimpse of the autobiographical nature of Justice Jackson. For me, and I think for many, many who are interested in him, one of the reasons that we have been grabbed is that he, the person, leaps right off the page. He's generally regarded as the best writer in the history of the Supreme Court. And I think one of the things he did distinctly was thought on paper, approached each case one at a time, confronted hard questions honestly, expressed uncertainty, drew on experiences, and of course regularly turned a beautiful phrase like the Chenery dissent, which, by the way, he held back. The case was decided at the end of a term in June, and he reserved his dissenting vote and wrote that dissent over the summer. And it is a long, blistering dissenting opinion. The more and more you explain, the less I understand. So this is a piece of the Frewsburg life. Robert Jackson attended a small, modest school in Frewsburg, the lower school and then the upper school. I think the bar forms of today pick up something that Jackson didn't have to disclose, because in high school he was expelled from the Frewsburg High School. And indeed, his first case, I believe, was representing himself before the Board of Education, petitioning for his readmission. And it was granted. It was a minor vandalism matter. And he was the valedictorian. They chopped down a couple of pillars and turned an upstairs classroom space into a basketball-friendly gymnasium. And some school authorities at first found this problematic and expelled him, and then it became the gymnasium officially. So, in Frewsburg, the schooling was demanding but rural. Most of the teachers were not college graduates. The curriculum was modest, and that's one of the reasons why Jackson, valedictorian from Frewsburg in 1909, travels by trolley up the valley. It's the Warren, Pennsylvania to Jamestown line. Frewsburg is an intermediate stop. He travels up to Jamestown as a commuter the next year and does effectively a second senior year of high school. But really more of a tutorial year where much more deeply educated teachers were available, and he, having satisfied the regent's requirements, et cetera, in Frewsburg, was really thirsty for more and got a kind of above high school education. History, literature, economics, declamation, oratory, debate, et cetera, poured into him. So when we say he didn't go to college, he might have gotten in that 1 year in Jamestown what a lot of people are lucky to get in 4 years of college. And then he becomes, as you've heard, a law apprentice. This is his Frewsburg senior picture. So over the next couple of years, Jamestown High School, and then at age 18, a law apprentice. That's Frank Mott, roughly in that time period, who Jackson apprenticed for. Frank Mott was a trial lawyer. He was a brilliant talker. He was a politico, a Democrat in Chautauqua County, which was not very friendly to Democrats in the time, so he was quickly Democratic County chairman, et cetera. He ran for Attorney General of the state of New York as his party's nominee and got wiped out early in the 20th century, but kept a hand in politics and brought his boy Jackson during this apprentice year, not only to court, but along on political activities. Jackson's forebears were Jeffersonian, Jacksonian, as in Andrew Democrats, and now Frank Mott, who was actually a distant relative of Jackson's mother by Mott's mother's late-in-life second marriage, and if you draw it as a family tree, it's a mess, was not just law, but politics. In 1911, before Jackson is at the Albany Law School, Frank Mott takes him on a political trip to Albany and introduces him to lots of people. State Senator so-and-so, Assembly Member so-and-so, and this is my boy Jackson. I don't know exactly what he said. And Jackson shakes all these hands. And Jackson's entirely forgettable. And frankly, for him, most of the people he's meeting are a blur. But Jackson, at age 18, did remember for the rest of his life that one of those hands that he shook in early 1911 was a newly elected state senator from Dutchess County, New York. He was 10 years older. He was called Frank Roosevelt. He was tall and thin and incredibly handsome, and generally regarded as a very rich, very lightweight. Luckily, he had personal money to pour into the campaign. Luckily for him, it snowed on Election Day, which depressed the farm turnout, but Poughkeepsie voted, and he by a whisker was elected to the state senate. And by the way, he had the surname of Colonel Roosevelt, the recent former president of the United States. And, never thought much more would come out of this guy, but there was the handshake. Well, in time, Frank Roosevelt becomes Franklin Roosevelt, and young Robert Jackson becomes the fellow we're here talking about. The other half of the law firm, the other sponsoring letter in the admissions file in the 4th Department, was written by this fellow, Benjamin Dean. As tutorials go, you want different perspectives and different talent sets and different backgrounds. And Jackson, maybe just luck of the draw, in Mott and Dean, got both of them. You see, Ben Dean, who Jackson later continued to practice with for quite a while, rarely went to court. He was no trial litigator. He was no talker. He was not a big politico wheeler-dealer as Frank Mott was. He was a scholar. He was a writer. He was a researcher. He was the brief guy. He was the appellate division teacher. He pointed Jackson to the books on the shelves and said, okay, let's begin with Kent. Read some Kent, and then we'll talk about it. Now let's talk about Blackstone. Now let's talk about Choate. Now, etc. And that's the other half, the intellectual influence, if you will, that Jackson has in this tutorial year. It's Ben Dean who tells Jackson, enough here with us in Jamestown, you should go to a school and get some book learning in the law. And Jackson considers the possibilities: Buffalo, Cornell, New York City, but the draw of the state capital, and no slighting of Albany now, but the draw of Albany in its time as the capital of the Empire State made it an easy choice. Plus, it was a 2-year program. Plus, they were going to give him credit for the apprentice year, so he was transferring in as a senior. And for a young man in a hurry, all these pieces aligned. This is the former building of the Albany Law School. You can tell it was previously a church. It was right downtown on the square, across from the state capitol building, from the Court of Appeals, et cetera. It's now under the Egg, is where this location is. It was part of the Rockefeller redevelopment, Empire State Plaza area. And Jackson, age 20, is a supernova of a student. To his surprise, Albany Law School that spring decides that it will abide by the bar's requirement that one must be 21 years old to practice, and thus one must be 21 years old to receive a law degree. To Jackson and two other 20-year-olds in the class, this was a big surprise. And for reporters, it was of interest that the other 20-year-olds were twin sisters, Clara and Clarissa Pritchard. And so this whole imbroglio got in the New York Times. You know, girls in law school, gender discrimination, age discrimination, twin sisters. It had, you know, great media grab circa 1912. Nobody ever mentioned the third 20-year-old, but the Pritchard sisters and Jackson, no degrees. Certificates of completion, and of course a transcript. And of course, a couple of decades later, when he's Attorney General of the United States, a matter of deep embarrassment to the Albany Law School, which gives him his degree, class of 1912. And you know the little dagger footnote that authors put in law review articles? Robert Jackson, with a little bit of a twinkle, would always refer to himself as Associate Justice, Supreme Court of the United States, LLB, Albany Law School, 1941, Nunc Pro Tunc, 1912. But he also served on the school's board and was a great supporter. And then he still had to come home and wait to be 21 to apply to the appellate division to become a lawyer. In Albany, he had met a dazzlingly beautiful young secretary at the State Excise Bureau. Her name was Irene Gerhardt. He brought her home to Spring Creek for Meet the Parents and Let's Go Fishing in the Broken Straw. Highly chaperoned, no doubt, weekend. That's them in their courting days. And in 1916, they married. And then Jackson begins this 20 years in private law practice. 1913 admission, 1913, 14, 15 practice in Chautauqua County, pretty much as a solo. Some kind of referrals from Mott and Dean. Pretty much anybody who couldn't pay them, they would say, see Jackson. And he started to spend a lot of time in the courthouse in Mayville, the county seat, and visiting judges down from Buffalo were doing the presiding in that courthouse. One was Charles Sears, and he sees this fabulous young lawyer, and he recruits him to Buffalo. Sears was new on the bench and had recently been a part of a leading Buffalo law firm, Penny, Killeen, and Nye. Penny was the former DA who had prosecuted the assassin of McKinley, you know, high-profile private practitioner. And Sears tells Penny, have I got the boy for you? And so Jackson, with his young bride, moves to Buffalo and practices law there in 1916, 17, 18. Principal client is the International Railway case, and thus that first appellate division case, an International Railway case, the traction company, the streetcars, personal injury litigation, arises out of his Buffalo years. But for all the contacts, development, stimulation, et cetera, that Jackson is getting in Buffalo in those years, he also is seeing the height of the ladder. He realizes that I can stay and I can work and I can rise, but it is a long climb to get to the top of the legal profession in the 10th largest city, booming economy, post-war Buffalo, et cetera. You know, I don't want to wait to be 50 years old before I'm president of this or, you know, the man to try that. I can climb to the top of the ladder faster in Jamestown, is Jackson's thought, and he explains this to people in Buffalo. His scenario is that the mayor of Jamestown, a Republican, recruits him to be the city's corporation counsel and brings him home. So there's a kind of bipartisan admiration for Jackson even at this early date. And he was right. He goes home to Jamestown and pretty quickly, across the next 12 years, builds a monster law firm. This is the four lawyers of Jackson, Manley, Herrick, and Leet. He was, on all of the reported cases, the big fish in this law firm. So pretty much everything they did was Jackson generated and Jackson led. He becomes a founding leader of not only the Jamestown Bar, not only the Chautauqua County Bar, but an association that I'll return to, the Federation of Bars of Western New York State. And from that becomes a very prominent New York State lawyer, and from that becomes very active in the American Bar Association. He's, as you heard, an oil and gas lawyer, among other things, and his network of oil and gas law includes a lot of Texas and Oklahoma buddies that you would be surprised to find in his Rolodex. He's elected to be the president of what we today call the ABA House of Delegates in 1934. In other words, he's up at the top of a ladder looking across at people in Buffalo and New York City, et cetera, who are 10, 15, 20 years his senior. That's his private practice. He also keeps a hand in politics. Not particularly active, but Democrat and supportive. And in 1928, when that former state senator, Frank Roosevelt, who had become then Assistant Secretary of the Navy and then a vice presidential nominee and then a polio victim, is recruited to lead the ticket in New York State because Al Smith, the governor, is the presidential nominee, and his name is still Roosevelt, and he's not Catholic, so he might actually lift the New York ticket and help Al Smith carry the Empire State. Frank Roosevelt runs for governor, wins big. Robert Jackson is involved in that campaign and in proxy speaking. And then in the two-year terms, so 1928, 1930 re-election, Jackson is much more involved in Democratic politics through Roosevelt and through the gubernatorial years. He also, and this is just a glimpse, was still the country boy. He'd built the big house in Jamestown with the white pillars. He had an 88-acre horse farm. He had a stable full of ponies. He had a boat on Chautauqua Lake. He had, life by, every measure that one could want. And he was not looking for anything else, which is another strand that runs through this guy. Not needing anything, being quick to say not for me, being available to look at things honestly and say no, comes from a kind of autonomy, independence, skill, comfort, and he had all of those things. But Washington called. This is a fishing trip, which is a theme I'll return to. I don't know how many fishermen and women we have here, but you don't dress this well when you go fishing. And you never guess that relaxed fellow on the left is gripping that pole so he doesn't fall over. But that's President Roosevelt and Jesse Jones, the Secretary of Commerce, and Jackson, who at this point is an Assistant Attorney General, and Harold Ickes, the Secretary of Interior, in the throes of a New Deal battle. And that's what Jackson did. He comes to Washington, after waiting for the right offer and kind of getting asked by higher and higher people in 1934, not 1933, 1934. He takes the job as Assistant Attorney General heading the Revenue Bureau, but he's not really a tax lawyer. He's a litigator, he's a corporate counselor, he's a municipal lawyer, he's an appellate lawyer, etc. So he leaves administration to staff and begins to fight fires, legislative battles, litigation battles like the Mellon case, and succeeds. And as he succeeds, he becomes more and more and more and more of an inner circle figure. And in part, that's the story he tells in That Man, and in part, that's the meteoric rise through these jobs. Revenue in 1934. He's briefly at the SEC as a special counsel in 1935 into 1936. He's Assistant Attorney General heading the Tax Division in 36. He's Assistant Attorney General heading the Antitrust Division in 37. He becomes Solicitor General in 38. He becomes Attorney General in 40, and he's appointed to the Supreme Court in 1941. And he's 49 years old. And he was nobody's anybody. He's just talent. In 1935, he starts to be magazine cover material. This is Supreme Court litigation before he was Solicitor General. He becomes Solicitor General, and that's a shot at him working at his desk in the SG's office. He loved that job. He said his 2 years there were every lawyer's dream. What better job could a lawyer imagine than representing the United States in the appellate courts, and particularly in the Supreme Court? He argued about 40 cases in the Supreme Court. Yes, it had changed. It was a congenial court from 38 forward. But he was brilliant and effective. Louis Brandeis famously said that Jackson should be Solicitor General for life. And it wasn't a sort of a penalty or a lockdown. It was a compliment coming from Brandeis. This is the court that Jackson began to argue before. In the front row next to Chief Justice Hughes, you see Brandeis with the great late-in-life Brandeis hair. And it's the court that first now has Roosevelt appointees. That's Justice Hugo Black in the back right corner, which was the first Roosevelt appointee in August of 1937. Jackson is wanted by Roosevelt for bigger things, if not necessarily better things. And so in 1940, he's elevated to be Attorney General. It's a complicated story about reviving the Justice Department after his predecessor had been kind of a disaster, and Roosevelt got rid of him by appointing Frank Murphy to the Supreme Court. You know, you're fired by promotion. And so Jackson is greeted by the employees in the Great Hall and is the Attorney General at the time where the Department of Justice is really the war preparatory legal advisor. 1940 and 1941. Britain is now standing alone, the destroyer deal, Lend-Lease, the resumption of the draft, etc., is the series of very complicated legal topics that Jackson is navigating as Attorney General. That's the AG's conference room. I had a great honor a couple years ago. Attorney General Holder invited me to give a Jackson talk in this room. So, of course, I used this photo. And on the walls, each AG gets to hang 4 portraits of his or her choice. And so Eric Holder has Janet Reno, for whom he was Deputy Attorney General. I think Nicholas Katzenbach as a sort of civil rights hero. And on the other side, Robert F. Kennedy and Robert H. Jackson. So I was standing about where this photo was taken, talking about this guy, kind of imagining him down at the far end of the room, but kind of glancing at him over my shoulder, and he did not object. In 1940, Franklin Roosevelt, second-term President Roosevelt, was intending to retire and to return to Hyde Park, where he'd already built the presidential library, to have a job writing newspaper columns. He'd already signed a contract, and to be something like Jefferson at Monticello, you know, the 2-term tradition, etc. It would have been a heck of a fight between urban Democrat machine politicians and the New Dealers to see whose candidate got the nomination, etc. But the New Dealers in early 1940, and this is part of Jackson as SG and as AG, are coalescing behind Jackson as their person. This is one magazine headline from early 1940. Roosevelt's choice for president is Bob Jackson. But events, and then of course Roosevelt's decision-making, went in a different direction. This is Roosevelt that spring, and it's January till April into May, and the world changes completely. Addressing the joint session of Congress, asking for $1 billion in defense buildup. France is about to fall, soon Britain will stand alone. And Roosevelt, for a whole mix of reasons, but part of which is the coming war and national security, seeks and wins, of course, the 3rd term, and Jackson takes a different path. He becomes that upper right corner junior justice on the Supreme Court in the summer of 1941. He loved this job, but it took him a while to kind of get comfortable in this job. He thought of it as different than everything else. Judging is not lawyering. Adjudication is not client or result or policy seeking. He really thought there was a role differentiation here that was very important. And it took him a while, age 49, age 50, to kind of adjust his temperament to this. And he found it appalling that a number of his colleagues did not seem to have the same perspective on the job. He was quickly a lauded, noted justice, the author of the Barnett opinion, the flag salute case, the dissenter in the Korematsu case, exclusion of Japanese Americans, many other things in those 4 years, 41 through 45. But he was not a happy justice. In part, Roosevelt kept telling him, just stay put. You know, frankly, we're fighting a war and you're useless, so I've got nothing I want you to help with in the executive branch. You're no warrior. And I want to put you in that middle chair in time. I guess having decided to seek a 3rd term, Roosevelt decided he would be president forever. Obviously, he did win a 4th term and lived briefly into that term. Harlan Stone was approaching 70 and was not a healthy man, and everybody sort of assumed the center chair was Jackson's destiny. But Stone outlived Roosevelt. And this poor guy on the left inherited an office and responsibilities and commitments that he had to figure out and needed big help in a hurry. Now, you know, the Manhattan Project is the most famous thing. Harry, Mr. President, we need to tell you about some things you don't know about. The Manhattan Project was at the top of that list. The commitment of Roosevelt, Churchill, and Stalin, beginning in 42, affirmed in public declarations beginning in 43, reaffirmed at Yalta in January of 1945, to prosecute the vanquished Nazi leaders as international criminals, is another item on that list. And Truman, President, April 12th, figuring out all these things, and the armies advancing on Berlin, has an intermediary go to the Supreme Court in late April 1945 to approach who Truman and everyone, frankly, regards as the best lawyer, the leading law figure in the country, Justice Jackson, to say, I need a lawyer. I need a lawyer for a big case. Frankly, it's the trial of Adolf Hitler. Are you interested? Now, I don't know what kind of work walks into your office, but that's a pretty big, representation, I guess. Jackson, a little bit discomfited on the court, already done writing his opinions for the term, getting wooed by the president, and of course when your president asks, when our president asks, I think one should always say yes. Jackson says yes. And he's told it's all assembled, we're about to capture him, we're about to win, the evidence, the cases, etc. You've got a summer recess, this fits perfectly. You can sort of do this international trial and be back on the bench by the first Monday in October. Well, among other things, Hitler doesn't show up. Others of the senior leadership also declined to show up. No evidence is assembled. No international agreement among the Allied powers has actually been developed in any kind of detail, et cetera, et cetera. So Jackson, having said yes, is now the sucker on the hook for this huge, complicated task. He regarded it as the most important work of his life. And we look at Nuremberg from the back end, and we know how it worked and that it generally worked and generally did amazing things. He had to live Nuremberg in real time from the front end. Improv, chaos, cracking ice under feet almost every day, and horrific conditions. Horribly cold winter, poor food supplies, no electricity, et cetera, et cetera. No doubt it shortened his life. No doubt he checked out at age 62, and he wrote this in many places, happy to have had his full span and to have had this opportunity. He thought it was the most enduringly significant thing he had been asked to do, that he'd been part of doing, and frankly that a human being could be a part of in his career. This is a building at Westminster Abbey called Church House, a four-sided table where he and British and French and Russian counterparts spent the summer of 1945 hammering out, in effect, a treaty, the London Agreement, creating the world's first international criminal court, defining its jurisdiction, defining its procedures, and getting this done in about 7 weeks from very different perspectives. The Soviets, of course, Stalin had committed to a process, but you know what a Soviet show trial is. The commitment to have a trial meant we will have a trial as part of executing these people. And what Jackson had to do is say, no, a trial means we don't have a foreordained result. We have due process, we have a burden of proof, we have an independent judiciary, we have a real prospect of acquittal. That's what we're in this for. And the British are right with the United States, and they say we too. The French are a newly reconstituted republic and not a significant player, but of a civil law nature, and a lot of the concepts of Anglo-American jurisprudence don't really compute for them either. And Jackson has to kind of go back and confer with that guy, that poor guy, and say, what do you want me to do here? In effect, I can start the Cold War. I can do a show trial. I won't be part of it personally because I'm a lawman, and for me, a trial means these various things. And Truman basically says, you do it your way. You have my green light, you have my total backing, whatever you think is right. Which, as executive guidance, is great, but empty. And think of the stress and think of the negotiations and so forth. Jackson basically tells the Russians across the table, we have physical custody of most of the prospective defendants, and we will insist on these various procedures. So feel free to sign up and do it our way, or who do you have in custody? And do it your way with people you have. And that stare down in late July, early August 1945 becomes the Soviet blink,
which becomes the London Agreement, which becomes a four-nation collaborative success story across the next year. This is signing the London Agreement, August 1945. Jackson, second from the right, and the principles of the four nations. They picked a site recommended by the US Army, which was in the US sector of occupation in southeastern Germany. It was our real estate, ours under control. It was Nuremberg, which also had sort of good optics. It was the site of course, the Nuremberg laws and the Nuremberg rallies, and now Nuremberg accountability for the Nazis. But most important was American sector of control. And that was another fight with the Russians who wanted it in Berlin in their sector. Now, this is the Adolf Hitler plots in the center of Nuremberg. It's been swept, but you can see the rubble, and you've seen, destruction photos. How do you do a trial in Nuremberg? Well, if you go there, you see that this structure, which was largely undamaged, it was damaged, but in parts, is on the outskirts of Nuremberg. And the front-facing building is a courthouse, and the wheel and spoke behind it structure is a large prison complex. And in a matter of 2 months, they build this courtroom out of the damaged rubble space. They assemble evidence, they draft and present an indictment, and in November 1945, they convene the world's first international criminal court, the International Military Tribunal. 22 defendants, 21 in person, 1 in absentia, and then 1 is incompetent, so it's down to 21 or 20 in person, plus 6 organizations. A corporate criminal case is what this trial is. It is the one and only Nuremberg trial that is an international trial. There are subsequent trials which are US-only proceedings, but this alliance lasted, the legal alliance, through 1 trial through this 1 year. The jurisdiction of the court is over 4 crimes, and most defendants were charged with all 4. Conspiracy to wage aggressive war, the commission of aggressive war or breach of the peace, the commission of war crimes, and the commission of crimes against humanity. Some of that is long established war crimes going back to the Hague agreements of the late 19th, early 20th century, and some of it is entirely novel. Crimes against humanity. And the institution is entirely novel. The International Military Tribunal, an international court, which leads to lots of interesting theoretical arguments about its legitimacy. Jackson had 2 positions. The first, which I'll caricature, was for deep and complicated reasons, this is legitimate. And, or, even if it's not, at least we're doing something here for the future. Because no person hereafter will ever be able to say, I didn't know I couldn't do that. I didn't know anybody had jurisdiction over that. And thus, Nuremberg for the Nazis and Nuremberg for the future was a dual perspective that Jackson had. He also made a decision which is fundamentally important to understanding the trial. He tried the case on captured German documents. It was an evidentiary documentary case, which can be boring as all get out. And as you read the press coverage, you see it get crabbier and crabbier across this year. But it is of unquestioned reliability and veracity. The records, of course, had been somewhat destroyed, but largely captured. And no defendant contested the authenticity of all these documents, orders, plans, meetings, minutes, etc., with his name, his signature, his presence. And that establishes what we know of the Third Reich. The historical record forevermore is built on the Nuremberg case. That includes the Holocaust, something that they are understanding in real time. They're discovering and proving something that, at first disclosure is too enormous to wrap your mind around. Jackson gets early meetings with World Jewish Congress leaders who say, the Nazis exterminated 4 million Jews. And then the second time they say 4.9. And the third time they say 5.8. And Jackson finds this incomprehensible. What's this based on? How could this be? Says Jackson in May, June, July 1945. And they say, well, it's math. Basically, the census of Europe before the war shows this many Jews. And with reproduction and mortality, this is how many Jews there should be. And the census data from displaced persons camp shows we now have this many Jews. A minus B equals the missing 5. In the end, we know 6 million people. Jackson finds that incomprehensible in June. He opens and asserts that as something that he will prove in November. And the case is filled with the documentary evidence that backs that up. Now, this is Jackson at the podium. His opening statement and his closing statement at Nuremberg are regarded as perhaps the best English language courtroom addresses in history. He also cross-examined 12 witnesses, something that's less appreciated. That's an early color photograph. I just love it for the color. The red light is the interpreters doing simultaneous translation saying, stop, you're way ahead of me, and the yellow light means slow down. There are very few hours of this long trial that were actually filmed, but as you watch the excerpts, YouTube, other places, notice the pace and think about doing cross-examination at, about a quarter of your ordinary speaking, because that's what was going on with these yellow and red lights. Jackson earns the Medal of Honor. That's Robert Patterson, the Secretary of War. And he returns to the Supreme Court after his Nuremberg year. It's the fall of 1946. It's the Vinson Court. They're laughing and jovial. Jackson's second from the left in the back row, big grin. They weren't always so jovial, and it wasn't perhaps history's greatest court as a body, but it had some of history's greatest lights as jurists. And of course, in 1953, Fred Vinson dropped dead, and Earl Warren, the new chief in the middle, becomes the successor, and this is the last court that Jackson's on. He's in the same spot in the back row. You notice how much more gaunt he is, because in 1953, his health started to fail. In 1954, he had a major heart attack. He spent 7 weeks in the hospital. He came back against doctor's orders to be physically on the bench, to be visibly part of the unanimity of the court in Brown versus Board of Education. And that October, 60 years ago, just a few days ago, Jackson, at age 62, dies of a heart attack. So let's talk a little bit, a few minutes, about Rochester. And I want to just tick off 15 glimpses of Rochester in this Jackson path. Each of these is a deep footprint, and I could give you 50 more. Jackson was, yes, Jamestown, yes, Chautauqua County, yes, Buffalo, yes, Albany, yes, Washington, yes, the world. But he was upstate New York in a way that was relevant and confident and included Rochester as a major locale. First, he was nearly from here. I'm stretching a little bit, but you remember Litchfield, Connecticut, and his ancestors? Elijah to the Western Reserve, his brother Uri to Ontario County. Oh, so close, right? Other moments that could have been Jackson early on, and no doubt he heard about. State politics, Democratic and Republican, ran through this county and this city. The 1908 convention, Frank Mott is a big leading spokesman, delegate, insurgency leader. 1910, same thing. 1912 campaign, Benjamin Dean, for his scholarly reticence, is out on the hustings doing a lot of speaking, including in Rochester. 1913, a third moment. Now Jackson directly. This is the appellate division admitting him. The documents are wonderful. This is where he is launched as a lawyer. A fourth moment. I'm working on the facts, but I've got him writing letters to his wife from Rochester in the summer of 1916. He's a newlywed. She's an Albany girl now living in Jamestown. And what's he doing? He's spending weeks in Rochester. He doesn't describe what he's doing. It's clearly law practice, it's litigation, or it's some kind of business client or something. But he's writing letters to her. These are among the earliest newlywed letters, and they're from Rochester. A fifth moment, and that's what this newspaper story gives you a glimpse of. The Federation of the Bar Associations of Western New York. It meets here in the Powers Hotel in June of 1928. It's in its second year of existence. Arthur Sutherland, does that name ring a bell to anybody who's a Rochester person of some seniority? Arthur Sutherland was a Rochester lawyer. He practiced with his father. He argued and lost Nebbia versus New York, which is a famous Rochester milk pricing case that went to the Supreme Court. The state beat the grocer. He represented the Rochester grocer. He went on to become a professor at Harvard Law School. I should add that he had gone there and he had been a law clerk to Oliver Wendell Holmes. So Rochester, Harvard, Holmes, Rochester, Harvard, a giant. Arthur Sutherland is a principal speaker at this meeting. And after All of that is done. The Federation elects Jackson to head the Federation of the Bar Associations of Western New York. It's 11 counties from the western half of the state, and Jackson is its leader. He'd been one of the founders, and now in year 2 he's the leader. A sixth moment, the October 1928 Democratic Convention. You remember Franklin Roosevelt being implored by Al Smith to run really 2 years before Roosevelt was ready. That nomination happened here. Roosevelt was in Warm Springs, so it's communicated by telegram. But the delegates who are here, the Roosevelt delegates and supporters, include Robert Jackson. A seventh moment, 1931, the creation of the New York State Commission on the Administration of Justice. This is a major sort of state-level American Law Institute, appraisal, study, and recommendation body. Some appointed by the governor, some appointed by the State Bar Association. Jackson appointed by the State Bar, working closely with Roosevelt. Some of that is in that man. And Sutherland hired by this body as a researcher and scholar. This is where their friendship begins to cement. Number 8, a 1933 speaking tour. This is little appreciated in the path that led Jackson to Washington, but he's turning down 1933 jobs to stay in Jamestown, but he's doing Democratic politics, and he is speaking in the fall of 1933 in support of New York State Assembly candidates who are Democrats to give Governor Herbert Lehman, Roosevelt's successor, the political support. And he gives a number of speeches here in Rochester and really catches the eye of James Farley, who's the Postmaster General and the head of the DNC, who insists that Jackson comes to Washington and starts to say, what job will you take? And that becomes the revenue job. Number 9, and from 1934 forward, Jackson begins fishing trips through this area with a number of his deep, long-time, lifelong Rochester friends. Don Daly, who was the postmaster of Rochester, his brother Vincent Daly, who was a political leader here, Jack McKeon, Louis Whaley, who was the chairman of Genesee Brewing, his son John, Fred Tobin, who was the head of the Tobin Enterprises, which was a big series of industrial concerns, Tom Nagel, et cetera, et cetera. Every summer thereafter, with very few exceptions, Jackson would get up here, usually in early July after the Supreme Court term. He'd get to Rochester, they'd go up to Cape Vincent, they'd get on an increasingly grand series of boats, they'd go up the river, they'd go across the lake, they'd camp, and they'd fish. And I'll show you some glimpses of that. Number 10. In 1936, Jackson comes here and gives a campaign speech on Jackson Day, Andrew Jackson, January of 1936. And it is a Roosevelt's first term deserves re-election speech. It is the pure politics Jackson. And that's a dimension of him I don't want to slight. Number 11, and this is just a glimpse of the cover of that speech. March of 1937, Roosevelt has won that second term, and Jackson comes back to Rochester to speak at the Democratic Victory Dinner. This is the program. How's that for a cocky cover, right? 46-2 is not a scoreboard score. Well, it's a state count. Of the 48 states, Franklin Roosevelt had carried 46. And the principal speaker at this Rochester dinner at the Hotel Seneca is Robert Jackson. Number 12, 1938. And this is a series of Jackson notes. The handwriting might have slipped a little bit by this point in his life, but this is how he would start to work. He'd doodle, he'd take notes, he'd outline some prepared remarks, then he'd dictate, and then when it would come back from his secretary, he would edit the bejesus out of it. And eventually, this craft of writing would produce these glorious, brilliant, insightful speeches. In 1938, his speech is about the difference between what the New Deal seeks to regulate and the kind of free enterprise American capitalism that the New Deal is no threat to at all. And it's utility holding companies that are in the first category, and it's George Eastman and the Kodak Corporation that are in the second category. This speech is on the Robert Jackson Center website, and I think it's a very good insight into Jackson at the sort of pinnacle of his New Deal power. A next moment, the 1940 campaign. I just want to mention this for a second. Frank Gannett of Western New York, of the Gannett newspapers, was something of a Mike Bloomberg of his day and was a leading prospect for the Republican presidential nomination in 1940. And Frank Gannett was gearing up to run against Robert Jackson. And what were they? They were friends. They'd known each other through Western New York circles for a long time, and there's wonderful correspondence and sort of proxy speaking and sort of trial debates of various types getting ready for this race. Now, in the end, Roosevelt, not Jackson, and Wendell Willkie, not Frank Gannett, are that 1940 contest. But it's not too far off of what might have been. A next moment, 1944. This is Jackson at the swearing in of his son, William Jackson, before Judge Harold Burke of the Federal District Court. Bill Jackson, like his father, became a lawyer and came to the 4th Department and was admitted. And on one day, he was admitted both to the 4th Department and to the Federal District Court, both here in Rochester. And the first, I think, is required. The second, I think, could have been done in Buffalo or someplace else. But for Jackson, that is another proud paternal Rochester moment. And finally, a 15th moment. September 1947, not very long after Nuremberg. This is the Federation's 28th annual meeting. Remember, it's founded in 1927, and now it's really in its maturity. And Jackson has become its former president up the ladder, and now he's done with Nuremberg. And he comes back and he gives, at this occasion, a really detailed, interesting account of the work at Nuremberg. It's informal, it's off the record. He's introduced by Judge Dye of Rochester in the New York Court of Appeals. He's introduced by Representative Ken Keating of Rochester in the U.S. Congress. They all talk about our beloved Jackson, Rochester's Jackson. And Jackson tells his friends in this large gathering how Nuremberg worked. And what he offers is the sort of lawyer's perspective on Nuremberg, not the presidential appointee perspective, but the lawyer's perspective. And what he's saying to this practicing bar group is that what we did at Nuremberg is what we do every day. We take on a matter, we identify relevant materials, we develop facts, we work with colleagues, we hone our thoughts, we work with care but dispatch, and we try to do our best job, honestly. We do this locally, we do this at the state, at the federal, and at the international level. It's all the same, says Jackson. And I think that is a message that redounds through the decades. Now, I'll close with fishing pictures. This is the group, I think, in 1944. This is the group in 1950. Another color photo. This is the group up on Lake Ontario at a camp, and Jackson is second from the right in the flannel shirt. For all of the skill and all of the greatness, he's one of us. And so I want you to think of how we remember him. This is the Documentation Center in Nuremberg, a museum and a study center on the rise and military defeat and then legal accountability of Nazism. This is the Robert Jackson Center in Jamestown, New York. This is the Palace of Justice in Nuremberg. At the courthouse itself, there's today a memoriam which studies the trial process and focuses on what Jackson did there. This is the Federal District Courthouse in Buffalo on the circle in the center of the city, which is the Robert H. Jackson U.S. Courthouse. He's all of those things. It's Judge Fascio's office. But he's also just one of us. A young lawyer with a clear gaze, a guy in the back of a huge room. We know from the seating chart that he and Irene had one of the worst seats in the House when the American Bar Association met in Buffalo in 1927. A man who put his pen to paper. I don't know if anybody uses a fountain pen, but there's something gloriously authentic about it. And he left yellow pages covered with this stuff. Another glimpse of a man putting his pen on paper. And a person who got to his feet to stand for and to express the best that we have as a profession. That's Jackson leaving Nuremberg. And notice, maybe I'm reading too much into it, he's kind of looking up and he's got this kind of future-oriented gaze. It's not an accident that he has emerged from history as the best writer, the hero and role model of every justice on the Supreme Court, the reader who law students pick up for the first time and go, wow, the voice that people hear and think, I'm learning something. And that's the process that Rochester, I'm proud, is claiming today, because you and we, legal profession in Rochester, were a big part of him becoming him. Thank you very much.
On the eve of the World Series, I feel like the quote man run lead, and I know that the mind can absorb only what the rear can endure, and you can endure about the next 10 minutes, and then you get your full 2 hours of sealed rest. So I will fly. Thank you to everyone, because for me, it's been a remarkable journey that we're actually here today. We're at the Second Circuit Judicial Conference. I'm having a conversation with a guy I only knew, didn't know what he looked like, a guy named Mike Wolford. Next thing you know, we're talking about his interest in Jackson. Next thing you know, I say, gee, wouldn't it be great if we did something on Rochester? Because of the order that was signed by Justice Scudder on the 100th anniversary of his admission to the practice of law, because if that hadn't happened, there would be no Robert Jackson Center. So we then met, talked, and I said, he became chairman of an event. He said, great, he followed up. Next thing you know, we're here today. I'm so thrilled to have Judge Fascio here to tell me about Allegheny College, and also to bring this script of the brief, because it talked about the pledge of the Allegheny College Second Century Endowment, because I was just asked to sign on the 200th anniversary of Allegheny College a pledge for the Allegheny College Third Century Endowments. So now I know whence it came and why they think they can enforce it against me. So all of this comes together, and of course John Barrett has been with us at the Jackson Center from the beginning, and I highly recommend this particular book. And I'll tell you just a quick vignette. When we got started in 2001, John got started working. He had just started working on the Jackson research, and he was contacting me, and we had a brief conversation, and he was trying to convince me of his legitimacy. And so he started sending me drafts of this thing, which turned out to be that man, so he could try to convince me, of all people, that he was legitimate. Right now, we're just the opposite of way, because I'm trying to convince John that we at the Jackson Center are legitimate. So I'm just thrilled that this was the end product. It got all kinds of awards, and just thrilled that he's here today. And obviously, you've heard all there is to hear about Robert Jackson and his biography. I have about 3 minutes to simply say that we in Jamestown, New York, created in 2001 the Robert H. Jackson Center to advance the legacy of Justice Jackson. And we do that through exhibitry, we do that through educational programming, and for all of us interested in the law, and that's why you're here today, is the fact that we've been able to have activities in Jamestown in conjunction with coordination with places like Monroe County, the Erie County, the federal courthouse. We've had it in Nuremberg, we've had various conferences, and we've focused in on areas of Robert Jackson's life and had a chance to interface with fellow Nuremberg prosecutors. They were able to come here while we still had them among us, to come and to talk about and to share Robert Jackson stories. We've had folks who were part of very famous cases that Robert Jackson participated on. Fred Korematsu came to Jamestown. We had the Barnett sisters, West Virginia versus Barnett, a very famous case of which Jackson wrote the majority opinion. We had actually the Barnett sisters, and one of the law clerks from Justice Stone was there. We had participants and the law clerks in the Youngstown Steel seizure case come, and all of these were covered by videography and C-SPAN and other things like that. We had Linda Brown. In fact, many schools from the Rochester School District came down to Chautauqua Institution to enjoy the opportunity to touch the hem of Linda Brown. We've had Nuremberg, as I mentioned, prosecutors and participants, law clerks galore. And through this process, we've established websites, web pages, YouTube. We have over 3 million hits on over 1,000 posts of interviews that we did with various folks. In fact, we were able to even get some clips that heretofore kind of unknown, and I just want to mention Reuben Ortenberg here. Reuben was in a law firm with Bill Mayers and Bill Zeck, Nuremberg prosecutors, and he was part of that process, and we have information on them. We are in the process of jumping into the celebration of the 70th anniversary of the Nuremberg trial. John so adequately laid out the major dates, but we will be going over to Nuremberg. We will be pausing and reflecting on a lot of the key components of the Nuremberg trial and its impact today. Its impact today has even found itself in activities we do at the Jamestown area Chautauqua Institution, of which we collaborate, and annually we have the International Humanitarian Law Dialogues, where we gather together all of the chief prosecutors of all the tribunals, current criminal tribunals, the International Criminal Court, Cambodia, Rwanda, Yugoslavia. They all come, join, share, and these are opportunities and legacies of Robert Jackson, who, as we heard, was the architect of really the first trial of its kind to find individuals accountable for crimes against humanity and its impact today. I wanted to make sure that you walk out with a few items which are Jackson Center related and which include, one of the things we did was how they covered Robert Jackson through the press in Jamestown, New York. You always, curiosity is, how do they treat their man? And that man, you know, in Robert Jackson, and as far as the court was concerned, so that's part of this here. I'm just thrilled. I'm also thrilled to know that I've been able, through this program, to capture the attention of my fellow partner, Mike Law, who it's the only time he would actually come over from Phillips Lytle to see me here. So, to Mike, thank you very much for coming for that. And for that, I'm going to want a photo op with him a little bit later. My time is up, and it's 2 o'clock. The good news, you get 2 hours of CLE, but I want to thank this panel, which was amazingly supportive, and to Louise Spinelli and the Monroe County Bar Association for giving us an opportunity to share Robert Jackson and his Rochester moments. For that, thank you very much.